transaction, and I thought, gosh, I've never ever talked about this. We're going to talk about mechanics liens. Because although hopefully you'll never see one, never have to use one, never anything, you should be aware of what they are so that if the situation comes up, you'll recognize it, right? That might cause a mechanics lien. So, and mechanics liens are, well, let's just start. I will share my screen. I know it's down here somewhere. Okay. Okay. So what's a mechanics lien? So if a person is hired to provide labor, services, equipment, or material for a real property and is not paid or paid in full for the services rendered, can record a lien known as a mechanics lien. And then after recordation of the lien, the claimant may foreclose on the lien to obtain payment. Okay, so a mechanics lien is when someone hires, and not the owner, someone other than the owner. Well, the owner could get a mechanics lien too if they hired someone to do work and didn't pay. But for the most part, where we would see this would be if a tenant or a buyer did work on the property and didn't pay, then the seller might be responsible for it if they don't do the process properly. So that's if a mechanics lien is filed by one of these workers, one of these people who provided services, then the seller, it goes against the property, and if the seller still owns the property, it's going to go against the seller. Okay, does a claimant need to file a lawsuit to obtain a judgment prior to filing a mechanics lien? This is against pretty much everything we do in the law, period, is you always have to file a lawsuit to get something. You don't just get to put it on because we don't really trust people to do it right? Or to not put one on when it was not necessary, or required. But in this case, that's all they have to do is file the mechanics lien, and it puts a lien on your property. They don't have to have a judgment. They don't have to have filed a lawsuit. They don't have to have done anything except for the proper steps, and which we're going to go over, and they can get a mechanics lien on your property. But if the mechanics lien is filed wrongly, it's not going to be enforced. Okay, so you don't have to worry that if someone who you never heard of files a mechanics lien, and then you could look into it. It's not necessarily, they still have to follow up with a lawsuit. Okay. Does it affect title to the property? Of course it does. It's a cloud on the property. Okay. And so by claimant, they mean someone who did work on the property. They have 90 days after recording the mechanics lien to take legal action to foreclose on the lien. Okay. So if they file the lien and more than 90 days, if the claimant doesn't take action, they don't file a lawsuit in 90 days, it's then they might still have a right, but for the most part, they have no right then to bring their mechanics lien. And the mechanics lien might stay on the property, but it should have no effect. So you might have to deal with it in title if there's one there, and you might have to somehow give them information so they can prove it was improperly filed. Okay, how is the priority determined? So again, different than everything else we know. Mostly, we know that the general rule with liens is it's determined by when the lien is recorded, and that's the order. But a mechanics lien is based on the date that the work commenced on the property. So it could go back a ways. If it was a long work of improvement, the mechanics lien could be ahead of other liens because it's the date of the work of improvement and not the order that it's recorded in. So something could be recorded before it and still not have priority over it. Okay. Can a person waive their right to a mechanics lien before work begins in the original contract? So they're talking about a contractor. Can you make your contractor waive their right to a mechanics lien in your contract? Sorry, even if I don't pay you, you can't file a mechanics lien, right? No, a person can't waive their right to record a mechanics lien in a construction contract. Okay, so you can't include a clause. However, gosh, how can a claimant waive their right? So you can't put it in the contract, but there is a written statutory waiver form. And if you get your contractor to sign that, it says, I can't file a mechanics lien. I can sue you still. I still get to collect the money, but it won't be through a mechanics lien. Okay. If a mechanics lien is recorded, can an owner of a property who wishes to sell or refinance a property take steps to prevent a mechanics lien from being a cloud on title, even though the issues with the mechanics lien have not been resolved? So I want to sell and I have this and I don't really want to pay it off just because I don't think I owe it. So yes. Sorry. So, helps to prevent a mechanics lien from being cloud, right? So they can file a release bond. You can file a bond. What's a release bond? A release bond is a bond that a property owner can obtain in exchange for the mechanics lien being removed. It protects the monetary interest of the claimant. So we're filing a bond. If the claimant wins, we'll have the title company will have the money to pay off the title company from the bond. Okay, so who can file? Any person who furnishes labor, equipment, or materials for any construction project or work of improvement, and any person who provides work authorized for a site improvement can file a mechanics lien. California law specifically designates direct contractors, subcontractors, material suppliers, lessors, or suppliers of equipment, laborers, and design professionals as being entitled to file a mechanics lien. So if you did something on the house and you're not one of these, you don't have the right to file it. You have to be one of those people. Does a claimant always need to be licensed? Okay, so now you're a contractor, you did the work, you want to file a mechanics lien. And so that they answer this kind of funny. No, a claimant only requires a license in order to record a mechanics lien if the work he or she did requires a license. So if it requires a license to do the work, which it does to do most of the works of improvement, then if you aren't licensed, you can't file a mechanics lien. So I had someone do that to me once, an unlicensed person file a mechanics lien against my property. I don't know, I sent a nasty letter and they took it off. But yeah, so if you don't want to, you want to make sure you take care of that if that happens. Okay. A direct contractor is the person, you guys probably know all this, is a person who directly contracts with the property owner. A subcontract is someone who contracts with a direct contractor. A material supplier is someone who supplies materials. Maybe all you did was supply the lumber or the windows or whatever. A laborer is anyone acting as an employee who does work on the property. A design professional is someone who designs, landscape architect, etc. Okay. Works of improvement and site improvements. That's kind of a pretty general term. Works of improvement, construction, alteration, repair, demolition, removal. I mean, it's pretty much everything. Oh, to a building, wharf, bridge, ditch, flume, aqueduct. Seeding, sodding, or planting of real property for landscape purposes. Okay, so that's also included. Filing, leveling, or grading property. Site improvements, demolition of works of, drilling holes, grading, filling in, construction or other installment of sewers and public utilities, construction of vaults, cellars, or rooms under sidewalks, or any work of improvement in preparing the site for a work of improvement. So if you go in first to prepare the site, then you're also included in a work of improvement. Okay, some persons who might improve a property but who cannot file a mechanics lien. Okay, certain persons, a tenant making improvements to the property he or she is leasing cannot file a mechanics lien. Persons who remove equipment from a work of improvement and an unlicensed contractor cannot file a mechanics lien. You have to be licensed to file a mechanics lien. Okay. What is a preliminary notice? So this is the part that that becomes more important because this is the part we can, I'm sorry, never mind, we're not quite there yet. Okay, a preliminary notice is a written notice that the contractor gives the owner that they're about to furnish labor and do all the stuff. And they have to give it a preliminary notice, claiming who, right, furnish labor. I think you have to give it, who does it go to? It has to be given within 20 days of the claimant has first furnished services, labor, equipment, etc. So apparently there are exceptions, but it's supposed to be in the notice must be given. So when I start the project within the first 20 days, I'm supposed to give a notice to the owner saying I'm doing this project if I'm not doing it for the owner. Okay. Which claimants are exempt from the requirements of serving a preliminary notice? Okay, the direct contractor doesn't have to serve a preliminary notice. And a laborer doesn't have to serve a preliminary notice, but all the rest of those people have to serve a preliminary notice. Okay, even though if I didn't highlight it, I didn't think it was that important. What information must the preliminary notice contain? Okay, the names and addresses of the owner, the names of the direct contractor or the construction lender, whoever it is that you're getting involved with has to be in the preliminary notice. Can the claimant include in the contract for work language where the owner waives his or her right to receive a preliminary notice? Okay, so we already learned that you can't make them waive their right to file a mechanics lien unless you use the statutory waiver. And then can the owner waive their right to get a preliminary notice? No, it's a non-waivable right by the owner. Any provision in which the owner agreed to waive his right to the preliminary notice would be void. Because we need the owner to know. We can't have people waiving these rights. Okay. How is the preliminary notice to be served? So again, as with most legal documents, there is actually a way you have to give it to the owner. So they have to serve it in person, by first class or registered mail, or by posting and mailing, kind of like a 3-day notice. The notice is effective when it goes in the mail. If service is by mail, it is effective when deposited in the mail or given to so if they have 20 days and they put it in the mail on day 20, they're okay, even though you aren't going to get it on day 20 as the owner. Does there have to be a proof of service completed? Yes, there does, because that's how we know that it was served in by one of those ways. What if the notice is not served, but a mechanics lien is filed? So what if you don't get a preliminary notice? The claimant who is required to serve a preliminary notice will not be able to enforce their mechanics lien. They're going to have to prove that they did the steps to enforce the mechanics lien. Okay, when can the direct contractor record a mechanics lien? And the direct contractor, after they haven't been paid, okay, they can record it. Owner after the direct contractor, yeah. If there's a construction lender, the construction lender must first have been given a preliminary notice prior to filing a mechanics lien. So you have to give the construction lender also one. No, we skip those. What is the time frame for a direct contractor to file? No more than 90 days must have elapsed since the completion of the work. And the completion of the work means when you stopped. However, if the owner has recorded either a notice of completion or a notice of cessation, then the contractor has no more than 60 days, which we're not going to deal with today because it's just even more complicated. Okay. Claimants other than the direct contractor can file a claim after they've ceased providing work. So while they're working, they can't file a mechanics lien, but if they say, hey, you're not paying me, I'm not working anymore, then they can go file it. We're going to skip this notice of cessation for today. Okay. What does a claimant do after a mechanics lien has been recorded? Okay, so then this is what they have to do. This is your contractor has to file a suit. Okay, and can the owner get the mechanics lien removed prior to trial? Yes, the owner, if the owner files a suit but they don't want the mechanics lien, they want to sell their property before trial, whatever it is, we already talked about this. They can either pay the lien or they can do a release bond. The title company will take a release bond and take the lien off the property. Okay, what happens to the mechanics lien if the claimant does not take action to foreclose on the lien within 90 days of recording it? The lien at that point is no longer valid. So if you don't if the lawsuit's not filed within 90 days, the lien just isn't valid. They can never do it. An owner should make a written demand to the claimant to expunge the lien. Okay, so I'm sure that you've heard this with lis pendens, when you take one off, you expunge it. I guess liens you also expunge. That just means get rid of. If it's not expunged, the owner can file a petition with the court to have it done because it shouldn't be on there. Okay. Okay. Lien releases. Okay, how can an owner be released from liability for a mechanic's lien? So my tenant or my buyer is doing a work of improvement on the property, they're paying for it. How can I be released? Okay. We already talked about though, they can't waive their right to it. Remember, the original contractor cannot contain a waiver, right? There are 4 types of waivers. We're not going to really go into the types of waivers, but if you're going to waive this, we know that it has to be a written statutory form of waiver. If you get them to the contractor to sign a written statutory form of waiver that says, I will not file a mechanic's lien. But there's better ways. Okay. Where can a property obtain blank copies of mechanic's liens really? Okay. Can a claimant record a mechanic's lien against a real property for non-payment if he or she contracted with a non-owner? So now they contracted with the buyer or the tenant, and the question is, can they still file the lis pendens against the property? And the answer is maybe. The owner of the real property could be held responsible for the work on the property regardless of who signs the contract if the owner had knowledge of the work, unless the owner posts and records a notice of non-responsibility. So this is what the owner's going to do so that they don't. So you find out your tenant or your buyer. In the case last week, it was a buyer going on to do to do some work before the close of escrow, and we didn't want to. The owner doesn't want to be responsible. The buyer has to pay for it. Okay. So when is an owner not liable for tenant or prospective buyers contracting for a work of improvement on the property? They won't be liable when they do it under the following circumstances. They never knew about the work. If you truly never knew and you could prove you had no knowledge of the work. And that means that the contractor obviously didn't serve you with the notice they were supposed to serve you with. Okay. A notice of non-responsibility is posted and recorded. Okay, so you can post, the owner can post, it's a statutory, it's also by law, a notice of non-responsibility. And so the owner work would be done on the property. There will be no liability on the owner if he or she posts and records a notice of non-responsibility. Okay, within 10 days about learning of the construction. So you're supposed to post it within 10 days about 10 days from when you found out that they were going to do it. Then the mechanic's lien will attach only to the lessee's improvements on the property. I don't even know what that means actually, as opposed to against the owner. If the owner has knowledge of construction but does not post or record a notice of responsibility within the 10 days, the court assumes that the owner is okay with it and will pay it if they don't pay it. That's all they can assume. Okay. So a notice of responsibility informs persons eligible to file a mechanic's lien that the owner did not commission the work and will not be held liable if the non-owner who contracted for the work defaults on the payment. The notice must be recorded by the owner in the county recorder's office and then posted on the real property in a conspicuous area. To be effective, it must be recorded and posted within 10 days of when the owner learns of the construction on the real property. Okay, I just want to show you really quick. Okay, so this is, let me make this bigger. This is the California preliminary notice giving you this not paid in full for labor services. The notice is required by law to be served on the undersigned statement of your legal rights. Okay, so please take notice that the claim, oh, this is a notice of preliminary notice, not a notice of non-responsibility. I'm sorry. I guess I didn't pull one, but I'll send one when I send this out. A notice of non-responsibility is used in situations where a person other than the owner, usually a tenant, hires a construction worker to work on the property. By posting this notice, the owner is denying responsibility for the work. So this is important for owners to do, but they have to both serve it and record it. And however the lien will attach, and I can tell you because we're doing one of these and Chicago Title is going to record it. They make you sign away everything before they'll do it. Gee, this is all true, and they really have asked for quite a few disclosures. Okay. Right. Okay. The notice of non-responsibility protects the owner only when the owner is not involved in the process and therefore is not truly responsible for the work. If you participate, then you would be still responsible. Okay, so how can sellers protect themselves from mechanics liens hired by prospective buyers? Okay, in the same steps that we talked about before. They're saying you put in your contract with the buyer that the buyer is going to be responsible if anything happens on the property, and it's already in our contract. So it's already in the contract. But again, if your buyer's gone and you can't find money, it's not going to help you any. Okay, I think that's it. Okay, does anyone have any questions on mechanics liens?
Yes, it's Tess.
Hi, Tess.
Cindy, is there an expiration on that mechanics lien?
Well, if you don't file a lawsuit within the 90 days, then it becomes void. And if you file a lawsuit, then you fight over it. But yeah, you have to, it doesn't sit there forever. It'll still stay on, but it won't be effective. It was after 90 days if no lawsuit was filed.
So does the title company required to delete that if they don't file a lawsuit?
That's what the law says. Now, what the title company say could be different, but that's what the law says.
I see.
That they're supposed to do that.
All right.
So yeah, I mean, again, this is stuff that you should be familiar is out there. You might not see one of these for a long time, if ever. But you should know that if you have a buyer coming on like we did to do a work of improvement, and we don't want to be responsible for it, then we have to either, get the buyer to pay up front or do something, or we have to file a notice of non-responsibility. Because we don't want to be, the buyer takes off and doesn't pay it, and now we're stuck, not only with no buyer, but also with the bill.
Hey, Cindy?
Yeah.
I came in a little late, so I'm sorry, but
Thank you.
is this once the property's in escrow with the new buyer? Correct? And then the buyer tries to
Right.
do work
Like
on the property without permission?
No, not without permission. Like in this case, the buyer's got a VA or FHA loan, and they have a bunch of a requirement that they have to do, and the seller doesn't want to pay for it or do it. So the seller said, buyer, you can come on the property and do it so that you can get your loan, but I want to file a notice of non-responsibility because I don't want to be responsible if you don't pay.
So FHA, VA, this would be more applicable than a conventional loan generally.
Well, I mean, again, have we seen buyers who are really, really want to move in on that closing date, and so they want to go ahead and do the flooring ahead of time or something else. It doesn't mean the sellers are going to let them, but sometimes you have buyers who do stuff like that.
Yeah, but I mean, I wouldn't recommend my seller agree to that, but some do.
Yeah, correct. Some do, right. People try to, yeah. So, but they should be aware that if they're going to let the buyer come on the property, you don't want to be responsible if the buyer doesn't pay.
So that's when you do the notice of non-responsibility.
And and it's going to depend on, like, sometimes buyers come on and it's a 1-day project or a 4-hour project or not very long. If you can get the contractor to give you a full receipt that shows it's paid already, right? That the whole thing's paid, you might be able to avoid having to record the mechanics lien. So, I mean, because, this doesn't work if on a 2-month project or a long project, but on a 1-day project, we can make sure it's paid like that day, and then we don't have an issue. We can get something from the contractor saying it's paid in full.
Yeah, I remember in the past, a situation, maybe more than one, where the buyers were there doing work on a fence or something, and they didn't even own the property yet, and the seller didn't know.
Yeah, well, that would not be
That's
good.
pretty crazy.
Yeah, yeah. Yeah, we've seen that before, right? We've seen buyers try to come in and do work without telling the seller. Yeah. Any other questions? Okay, well, the other thing, I had a car call on Friday, and they had a couple of updates about the so I didn't know this, but apparently if you have a VA loan, you're not allowed to pay your agent.
Buyer can't pay the commission.
A commission, correct. So keep that in mind, because that's a whole nother ball of wax, right? Now we have anyone who has a VA loan, they can't even pay their agent.
Well, they're trying to protect the buyer all the
Right,
time.
of course,
so-
and doing a better job than the government. Yes.
Cindy,
Um,
Cindy, can you repeat that about the VA?
I'm sorry, what? Repeat it. A VA, apparently if you have a VA loan, you are not allowed to pay the buyer's agent's commission. That might change
You mean,
now. I mean, that might
is that
change
the,
with everything else.
What do you
is that
mean?
what the, wait,
Is that the
wait a
new
minute, Tess,
law?
Tess, wait a minute. Yeah, that's what I was gonna, is that the new law?
It goes what?
Is that the new law? With the NAR, with what's going on with the,
No, that's already the law. They were just pointing it out.
oh, okay. I didn't
That's
know, I
already
didn't
the
know
law.
that.
That's why it's kind of confusing. Like, what are you going to do with your VA buyers, right? They can't pay their own.
Okay.
So wait, hold on one second, Cindy. What you're trying to say is if the seller is not paying commission, and then we ask the buyer, which is the buyer broker agreement, that the buyer will pay commission. If it's a VA loan, it's not allowed. Is that true?
At the current time, but it may change. I mean, maybe VA will go and say, hey, with all these changes that they're making, we have to be, have this be a choice. I don't know. But yeah,
I think that that's the disadvantage on the buyer point of view, because no one is really representing them. Don't you think?
what do you mean?
In other words, if the agent will not be paid and the buyer is not allowed to pay the commission of the buyer, who's going to work for them?
Oh, right. Well, right.
Well, most VA buyers don't have much money. That's why they're VA. Besides, they were in the military.
And they talked about the
Wow.
fact that as a listing agent, you could offer different commission to different buyer's agents, right? You don't have to be across the board. It could be depending on how much the offer, it could be based on a lot of other things. But the worry, of course, is that this is going to set back discrimination like forever. Is that people will be discriminating because they can. So be careful about that, right? If you're going to offer different amounts of commission to different people, just be careful that it's not based on anything that's a protected class. And it's really truly based on the amount of the offer or whatever things.
So let's play this, Cindy. If I get a buyer and they're telling me that they have a VA loan, I mean, an agent can just walk away from working with that client. Is that true? Would that be discrimination?
No, not if they're not getting paid the amount they want. That is not discrimination. Discrimination is when you offer all of the white agents one price and all of the non-white agents another price, or all of your
Yeah, but
Chinese right.
if the buyer comes to me and says, I do have a VA loan, and so the chances of me being not paid, what's my choice?
Well, you got to get it from the listing agent.
But Tess, doesn't that, listing agents normally do that? They first go for conventional, then they go for FHA, and the VAs are the last ones that people
The
choose.
last one.
Right, but if they don't have choices, right.
Exactly.
Wow, I feel bad for the VA people.
I don't really think that we've seen any more fallouts from VA loans than from anything else.
No, because even when I was a listing agent and a buyer agent, when I present an offer, which is a VA, the listing agent normally don't even take it. It kind of changed a little bit now, but most of the time, especially if the agent is kind of ignorant about the VA transaction, they don't accept. They usually want either a conventional or FHA loan.
That's exactly what I just said, Tess.
Yeah.
Right, it's a
You're
last
right.
choice anyway.
Yeah.
Well, it depends too on the area. If there's a lot of military, a lot of sellers don't have a choice but to sell FHA or VA.
And one of the things that they made very clear is nothing's changed yet. They said that the car is getting a zillion calls. Oh, how do we do this? Well, it's not there yet. That's why you're not doing that yet. You know, people are trying to use the new ideas without the new forms. And so just until it happens, we're just doing the same thing. As you know.
Right, got it, thank you.
You know, and it's the
Okay,
it's the same
if
thing
anyone
with
has any
VA offers
questions,
right
I'm
now a
here.
little bit, and that is that every time you have a VA buyer, which may or may not be often, I don't know, but every time you have a VA buyer, you're talking to the other agent about whether or not a VA offer would be acceptable, or whether the house is acceptable, or whether anything is acceptable, because there are already some costs that the seller has to pay for a VA buyer with regards to like escrow fees and odds and ends.
Yeah.
And so you're already hopefully checking that kind of thing out ahead of time. And that's an easy time to find out whether or not the seller is offering a commission of any kind. Because by the time we roll this out, it won't be in the MLS. But for the next few months, it is.
Right. And so just keep doing what you were doing, but learning the new stuff.
Yeah.
Okay. I'm trying to think if there was anything else. Nope. The big thing was people are starting to use CBCs to ask for commission, and they didn't think that was yet appropriate. Or necessary, because it's in the MLS. Okay, if anybody has any questions, I'm here. I'm sure Terry's around. And we will be here to answer your questions, because there's a lot of change.
Thank you, Cindy.
Thank you.
Thank you,
Thank you.
Cindy.
Good job, Cindy.